Good morning.
Morning.
My name is Amy Campanelli, A-M-Y-C-A-M-P-A-N-E-L-L-I. I am the Public Defender of Cook County. Reform of the criminal justice system in Cook County and throughout the state has been the focus, as many of you know, of much needed attention in recent years, thanks in large part to the leadership of President Preckwinkle, Chief Judge Tim Evans, and the other stakeholders and the justices of the Illinois Supreme Court. The issue that has gained the most momentum in Cook County is the issue of bond reform, and whether an accused, which many of them are my clients, who is otherwise eligible for release should be incarcerated until trial simply because he or she cannot afford to pay bail. The Cook County stakeholders have all signaled their support for bail reform. Cook County Sheriff Dart has publicly advocated for reform for many years. Last November, Commissioner Chuy Garcia introduced a resolution before the Cook County Board of Commissioners calling for bail reform and held a public hearing on the subject. Most recently, Chief Judge Evans issued an unprecedented new general order for the Circuit Court of Cook County, addressing and providing remedial measures to address these concerns. This order of Chief Judge Evans' latest step in bond court reform in Cook County, following his adoption of the Laura and John Arnold Foundation Public Safety Assessment Tool in 2015, and his formation of a pretrial service division in 2007, has led the efforts for bond reform here in Cook County. However, since Judge Evans' order can only apply to his jurisdiction here in Cook County, it is essential that any reform be implemented by a permanent and uniform statewide solution. So as the lawyer for most of the pretrial detainees in Cook County, last year, I asked former United States Attorney General Eric Holder to review bail practices in Cook County. I was motivated to make this request after learning of Mr. Holder's analysis of the bail statutes and practices in the state of Maryland. Mr. Holder and his law firm, Covington and Burling, agreed to do this on a pro bono basis for me, and on July 12th of this year, provided me their memorandum of law. The Holder memo reviews the progress that Cook County stakeholders have made and recommends a number of measures that the stakeholders have long supported. I see Mr. Holder's memo as providing an impetus for change and a great step forward for bond reform in our state. The key recommendation that the stakeholders are calling for today is to start the process by requesting that the Illinois Supreme Court consider issuing new rules that would require any monetary bail determinations be accompanied by a hearing and a finding that the accused can in fact afford to post the amount in question. The stakeholders agree that pretrial reforms should be addressed not only here in Cook County, but all over the state of Illinois. At this time, 3 of the stakeholders in the criminal court system are on the dais with me. First, let me introduce Sheriff Tom Dart, a former prosecutor, Illinois State Senator, and State Representative. Sheriff Dart oversees the Cook County Jail, as you know, one of the largest single-site jail facilities in the country. Sheriff Dart has taken the lead in calling for greater awareness and better treatment of the mentally ill, and has been a leading voice in favor of bond reform. Sheriff Dart has also worked with my office to remove from his jail nonviolent arrestees who do not belong there. I now ask that Sheriff Dart say a few words.
Amy, thank you so much. I can't thank Amy enough for what she did here and for all the other folks that are here today. Amy took it upon herself to get this opinion from Eric Holder, and it is something that it's fantastic because it sort of lays the groundwork for anybody who may be opposed to the notion that people do not deserve to be in jail because they're poor. And it's something that we have talked about for quite some time now, and it is the unfortunate reality that in our system now, many people, hundreds of people, sit in the jail not because they're dangerous, not because they won't show up for court, but frankly because they're poor. And that is not what our system's about. It never has been. And this will go a long way to curing that. It's long overdue. On a given day, I have over 100, 200 people who I guarantee there's nobody who would suggest that these people represent a danger to anybody, but they sit there because they're poor. And so at a time where we have violence in the city of Chicago and we have homicides that are out of control, we need to make sure we're focused on those cases, not sitting there because the system is indifferent, just holding people because they're poor or they're mentally ill. And that's exactly what Amy went about doing, and that's what this will do. It will ensure that the people that should be in a jail, the people who are dangerous, who provide issues for our communities, who are people that I think we'd all agree should be in jail, they're there, but the other folks are not there. That is not what a just system does. And from just a pure logistical standpoint, from our side, I cannot emphasize enough to you the amount of issues it causes our office to try to work with all of these people who shouldn't be there in the first place, because we're providing them with all the mental health type of services that they should be getting on the outside. We're doing it all. Is it expensive? Yeah, it's expensive, but logistically, moving all of these people, it's incredible. And the amount of people we house because they're poor, they have a lot of health needs. On any given day, we're moving hundreds of people to doctor's appointments. That is not what a jail was ever set up to do. And instead of focusing on the dangerous people, the people that are threatening our community, we sit there with people that are no more dangerous than you and I. And so what Amy has done here is, I can't thank her enough. This is fantastic, and it is really taking our state, our county for sure, a long way to being the county that I think we all believe it should be. So I just wanted to thank Amy, and I want to thank all the other folks who are here today who have worked so hard on this. Just thank you so much.
Thank you, Tom.
Thank you, Sheriff.
Thank you. Next, I want to introduce Clerk Dorothy Brown. So Dorothy Brown is the clerk of the Circuit Court of Cook County. First elected in 2000, Clerk Brown is the official keeper of records of all judicial matters brought in Cook County, one of the largest unified court systems in the world. Her support and cooperation is essential for any progress with bond reform. And I welcome Clerk Brown now to say a few words. Thank you for coming.
Thank you, Amy, and certainly I want to thank Sheriff Dart as well as Commissioner Garcia for taking the lead on this particular issue. Of course, my office is responsible for collecting the bonds, and we certainly follow whatever the judiciary indicates. I certainly want to make sure that as an African-American woman, and of course, Amy can tell you that the majority of individuals that are in the jail are African-Americans. Also, many of you know that I am probably considered the expungement process queen, if you will. From that standpoint, from the standpoint of having many expungement summits, because individuals that are in jail wound up being innocent, and they're in jail for some of these nonviolent offenses, and they're innocent, and they need to get their records expunged. And so we have to go on the back end. People are losing their homes, they're losing their jobs, many times custody of their children. It's changing, it's really destroying their lives in so many instances unfairly. So that's why I am certainly in favor of this. I also feel that it's important that we balance the public safety of our citizens, and I think that this particular memorandum put together by former U.S. Attorney Holder takes that into consideration. And so I came today to show my support and to let Commissioner Garcia, Amy, and certainly Sheriff Dart know that I am in full support of whatever kind of bail reform that we can get done to ensure that we're not continuing to destroy the lives of individuals. And these individuals are people that we know are not flight risks, and many times they're innocent. In many cases, they're innocent. So whatever we can do to stem this disproportionate minority confinement and those kinds of issues, I am certainly in support. So thank you for taking this on, Amy.
Thank you so much, Clerk Brown. And last but never least, Commissioner Jesus Chuy Garcia is the Commissioner of the 7th District on the Cook County Board. As the chair of the board's Criminal Justice Committee, Commissioner Garcia presided over a hearing at which I testified on pretrial justice last November, and he invited national experts to share best practices on alternatives to pretrial detention. Previously, a deputy water commissioner, Chicago alderman, and Illinois state senator, Chewy was also the executive director of the Little Village Community Development Corporation. He has devoted his life fighting oppression and helping the poor and vulnerable. 2 years ago, he received wide-ranging support in his bid to be mayor of Chicago. With thanks and appreciation, I ask Commissioner Garcia to come to the podium and say a few words. Thank you.
Thank you, Amy, Clerk Brown, Sheriff Dart for being here, and the other stakeholders who are playing a significant role in Cook County to ensure that there is justice for all and that we end wealth-based cash bail practices in Cook County and hopefully in the state of Illinois. Amy Campanelli, our public defender, has done Cook County a great service, the state of Illinois a great service by requesting for the legal memo that you have today from the former highest ranking law enforcement officer in the country that lays out a very compelling case as to why Illinois needs to move forward, which would be very, very beneficial for Cook County if the Illinois Supreme Court deems it to be in the interest of the state. And I think that if they believe in justice, they will act upon the request that we're making today. That is to move us away from the system of wealth-based cash bail practices across the state of Illinois. This is a significant time in the history of Cook County, and given that you see a grouping of stakeholders, unprecedented, who had come together and said it is time to move forward, and now the request is being made to the Illinois Supreme Court to act as swiftly as possible so that we can ensure that there is justice for all and a beginning of a decline in unnecessary incarceration and detention of people simply because they cannot meet a financial cash bail that has been established. This will call for a hearing to determine if the person can actually afford, has the means to be out on bail or not. Something that is lacking right now across Illinois. So again, thank you, Public Defender Campanelli and the stakeholders who have made this a real possibility. In your packets, you have a copy of the full memo, which we are going public with today, as well as a 2-page Cliff Notes, the shorter version. We took out the highlights of the full report for easy reference for everyone who is here today. Thank you so much, and now we'll take questions, I suppose.
Thank you.
Do the judges have that, can they set the kind of bail that they want for those lesser crimes, or is it, are they mandated? Do you know what I'm saying?
Well, I think when you look at the bail statute, Chief Judge Evans' new order that he just issued, and now the Eric Holder memo, which supports Chief Judge Evans' order fully. And just now, I'm asking to expand it to the entire state so that my fellow public defenders and defense attorneys and judges across the state will have the benefit of the same thing that Chief Judge Evans has done. The judges must follow the law. And the law that is going to be in effect in January and the order that Chief Judge Evans just issued is that if you are going to set a bond requiring my clients or any client to post cash, there must be evidence on the record that he can in fact post that amount. The present ability to pay. That's very important. That's different, and it's an extension of the bail statute.
So, we've been talking about this for a long time now. What do you expect Holder's opinion is going to change right now?
Well, I'm hopeful that Holder's opinion will obviously support Judge Evans and the judiciary in looking at things a little differently in bond court every day, but that the Illinois Supreme Court will look at the Holder memo along with the law that was just passed and which will be effective in January and say, look, we need a statewide reform here. Everybody should be treated the same, just like Commissioner Garcia said. We can't have people in Cook County looking at the present ability to pay, and they are getting released on I-bonds or I-bonds with conditions, but the rest of the state is being held in custody because they're poor. So we need uniformity and we need permanency, because unfortunately, Chief Judge Evans will probably not be the chief judge forever. And another chief judge could come in and change the system and write a different order. We don't want that.
Is the state's attorney on board with this?
She is. She is. She just couldn't be here today. All the stakeholders support this.
So this will be law in Chicago in January of 2018, but you want to take that Holder finding paper and make it statewide and go to the Illinois Supreme Court to do that?
I do, and we have to go to the Rules Committee first. What Chief Judge Evans' order states is that beginning in September, specifically September 18th, the judges will have to make a finding on the record as to why they are issuing a cash bond, a D bond, and then they will have to make a finding on the record that in fact the person standing before them can actually afford to post that bond.
Now, two quick questions. First, how close to what you want to see statewide is the present situation in Cook County? I mean, there are a lot of recommendations there, but how close is Cook County moving or has moved toward those full recommendations?
Well, the full recommendations are obviously for a statewide pretrial service assessment, risk assessment. We've started that in Cook County. The training of the judiciary is a recommendation of Eric Holder. Chief Judge Evans has started that. There's more to happen in training. And the other recommendation is obviously to make these findings in court and hold the judiciary to that standard. So we've come some way, but there's more way to go, as we see, because you heard Sheriff Dart tell you today. I mean, even today, there's probably at least, a couple days ago, it was 204 people were sitting in custody that only needed to post $1,000 or less. That's a mere amount, and they couldn't post it because my clients don't even have $100 sometimes to post. So those 200 clients need to be part of this program, and other clients who are low to moderate risk as danger or a flight risk.
Yeah, and I want to just follow up with that. When we talk to police chiefs about this issue, they acknowledge that there are probably a lot of people who shouldn't be in jail for those reasons, and you have the monetary test, but they worry about the test for whether these people have a record of coming to court when they're supposed to, if they've had previous charges, if they're a danger or those things, and that they're afraid those tests may be pushed aside somewhat.
Those tests will absolutely not be pushed aside. That's why Chief Judge Evans brought in the Laura and John Arnold Foundation to put a risk assessment tool in place. That is a great tool. It's not the only tool. To look at each individual client who appears in bond court and make a recommendation to the judiciary whether this person is a danger to public safety or whether this person is a flight risk. And they give that person a number. And if someone is a 5.5 or a 6.6 on the scale, the highest is 6, that person is a danger and should not get a bond. Quite frankly, that person should be held on a no bond status. And I know that is very bold for me to say, but I am a citizen too, and I have to have credibility. And if people are a danger to public safety, looked at the safety risk, looking at their criminal history, looking at the charges, that person should be held no bond. Cash does not make us safer. We know because clients post cash and they might be a public safety risk.
One more thing. So what kind of crimes are we talking about that would get that kind of a bond?
Well, I think anything, okay, we don't have capital crimes anymore, but anybody looking at a life imprisonment as a possible punishment upon conviction, anybody who has a felony conviction where the mandatory sentence is prison, the judge can consider that. I'm not saying they have to give a no bond. And then they would look to the risk assessment tool from their pretrial service and listen to the mitigation of the defense attorney to determine, can I release this person back to their community on an I bond? Can I release this person on an I bond with conditions? Does this person qualify for the bracelet or home monitoring or curfew? Or perhaps this person should be released and have to make some drug testing drops or have to have mental health treatment. This is what they're doing across the country, folks. You know, in DC, they release 90% of the people who are arrested into the community. They do not re-offend. We will look at the outcomes. We will come together and find that people who are released are coming to court. They're not re-offending. They are not a danger.
I guess Amy, what I'm saying is, in your experience, what are these like drug offenses where people get,
I think-
$1,000 and they can't
yes.
afford? Are they, what kind of
The offenses right now where people are sitting in Cook County Jail are a lot of drug offenses, including cannabis offenses, a lot of criminal damage to property, criminal trespass to land, retail theft, driving on a suspended driver's license. These are the kind of people we see, violations of probation, where perhaps they didn't commit a new crime, they didn't report to the probation officer. Is that person a danger? You tell me. No, they're not a danger. We need to rope that person back in, bring them to the probation department, bring them before the judge and say, look, you have to follow these conditions. And some of the recommendations from Eric Holder's memo talk about holding people in contempt of court instead of locking them up, fining people who don't qualify for the conditions of their bond. There's other things to do than put them behind the walls.
What percentage
Go ahead.
of people currently in jail do you anticipate would be free on something other than a cash bond? If this were to take effect, if it was implemented, Holder recommended, how many people currently in jail would be out on the street right now?
I think it's safe to say anywhere between 25% and 50%. At the high end, I would say it's 50%. At the low end, I'd say it's 25%. Our jail population should be about 4,000 people.
Amy, I want to
Go ahead. Yes.
respond in
Yes.
Spanish to a question that was asked by the Spanish language media. Esta mañana, los oficiales claves del condado de Cook nos estamos reuniendo para hacer una petición a la Suprema Corte del Estado de Illinois, pidiéndoles que emitan un nuevo reglamento, terminando la práctica de cómo se impone una fianza monetaria a personas que han sido arrestadas y son detenidas en la cárcel del condado de Cook y después en todo el estado de Illinois. Queremos que el sistema funcione para todos y no solo los que tienen el dinero para poner una fianza. Si va a haber justicia y la justicia va a ser justa y ciega, entonces lo que debe determinar si la persona es detenida o puesta en libertad es si la persona es un riesgo para la comunidad, no si tiene acceso a dinero que tenga su familia o que tenga en el banco, sino que la justicia debe ser totalmente imparcial para toda persona, no obstante si la persona tiene dinero, o sea, una persona rica o una persona que apenas tiene suficiente para proveer por su familia. Entonces, la petición que hoy hacemos a la Suprema Corte es que cambie las reglas para que haya justicia para todos en el estado de Illinois y también en el condado Cook.
Thank you, Commissioner. Are there any further questions? We thank you all for coming, and hopefully you will read the memo. And if you have any follow-up questions, you can certainly call my office or any of us here.